Hello and welcome to another instalment of the Bellevue Brief, Bellevue Law's very own podcast series. This episode, which we're recording on the 28th of January 2026, is part of our mini-series of quick 10-minute explainer guides designed to help businesses and HR leaders understand the key provisions of the Employment Rights Act 2025, or the ERA for short, and crucially, what those provisions will mean in practice. I'm Chloe Grant, an associate in the employment team at Bellevue Law, and I'm here today with my colleague, Leigh Edgar, who's a senior consultant in the team. Hi, Leigh.
Hi, Chloe. Today we're diving into a topic that should be on every employer's radar, and those are the changes to the law on large-scale or collective redundancies under the ERA, with changes rolling across 2026 and 27. And this is one of the biggest shake-ups in UK redundancy in decades, isn't it?
Absolutely. I completely agree. And I think in terms of the rationale behind those shake-ups, it feels like there's really quite a strong policy push to ensure large-scale layoffs aren't happening without genuine workplace engagement anymore, especially, I think, after we've seen several really high-profile mass redundancy cases in the last few years.
Absolutely. The changes make it more likely that you will have to consult on this collective basis, and actually more expensive if you don't. So this topic is really relevant to people who are making any large-scale changes within their business. And it's more important than ever, I think, to consider your obligations right at the very start of the planning stages.
I think you're absolutely right. You know, the sooner the better. But before, Leigh, we dive into what's changing, maybe it's worth doing a quick recap of the current law. Now, redundancy situations can be individual or they can be collective. Where 20 or more employees are affected in a collective redundancy exercise, that's when additional obligations to consult those employees kick in. So I wonder if you could maybe tell us a bit more about the current position on collective redundancy consultation requirements to get started.
Of course, let's start with the basics, although this is a really technical area of law. So right now, collective consultation obligations kick in when an employer proposes 20 or more redundancies within a 90-day period at one establishment. Okay. Now, there's been lots of discussion and case law about what one establishment means. It could be one site, one shop, one warehouse, one company within a group of companies. And obviously, hybrid and remote working has not helped that, has it? The consultation itself, being collective, means that you have to consult with a trade union or with elected employee representatives, which obviously you have to elect if you don't already have those in place. And also the other requirement is that employers need to notify the Secretary of State using a form HR1 before the consultation starts.
Okay, so quite a bit there, but that all makes sense. Thank you. I wonder, what about the timings that employers need to pay attention to?
Yeah, they are strict. So that's why you need to know about these, and they impact on how your changes can be rolled out. So the consultation has to start early enough so that it's genuine, so that it's at the proposal stage, and it has to last for a minimum length of time depending on the number of employees that you are proposing to dismiss. So if it's between 20 and 99 proposed redundancies, employers must start consultation at least 30 days before the first dismissal takes effect. And if there are 100 or more employees who you're proposing to dismiss, then it's 45 days. And you have to put in your HR1 form before that consultation starts.
Gosh, okay, thank you, Leigh. Well, as well as all those key points, I think it's worth flagging too that as of late last year, 2025, the HR1 form became digital only for the first time, which I think, I don't know about you, caught a few employers by surprise.
Yes, yeah, I agree with that. It was a bit of a stealth change. And it's important to note also because of the penalties that you can incur as an employer. So in relation to the HR1 form, obviously not filing an HR1 correctly is a criminal offence, and there are fines and penalties and individual liability for directors if that isn't done properly. But also if the consultation isn't done properly, then employers might have to pay what are called protective awards to each employee. And at the moment, those can be up to 90 days actual pay per employee. So that's a bit of a whistle-stop tour of the current position. Chloe, looking ahead, what changes are going to come out of the ERA?
Well, I mean, there's a few quite significant changes, I think, in the redundancy space. And probably the first one to talk about is coming in from April 2026, and that's in relation to the protective awards you were mentioning. So the protective award for failing to consult will double, the maximum award, I should say, will double from 90 days actual pay to 180 days actual pay per employee. And I think we should flag that so far case law is suggesting as well that tribunals will start, at the maximum and then potentially reduce down with mitigating factors rather than taking the opposite approach. And I think, make no bones about it, these are big changes and it's big news because what they mean is that mismanaging collective redundancy exercises effectively becomes twice as expensive. So for employers dealing with large restructurings in particular, the financial risk becomes quite eye-watering, really. And that makes it, as you said, all the more important to plan ahead and make sure that your processes are fair, they're robust, and also they're transparent too.
Yeah, it's even more important given the other change that we're expecting to come out of the ERA. Can you tell us a bit more about that?
Yes, I can, because it's really the other headline shift, I would say, under the ERA. And that's a bit more technical, I think, this one, where instead of the one establishment trigger for collective consultation that you talked about earlier, we're going to have instead what's being referred to catchily as a new multi-site consultation trigger that's expected in 2027. Now, it's a bit of a mouthful, but essentially it means that from next year, collective consultation won't just be about one site or about one establishment anymore. Instead, the ERA is going to introduce this second consultation trigger that looks across a whole organisation and not just at the individual establishments like those shops or offices or even companies in a group, as you've explained.
Yeah, but we don't know yet what the test is, do we?
No, we don't.
So it could be a fixed number, it could be a percentage. We don't know yet. So it's still to be defined. So we're going to have to watch this space.
I think we absolutely are. That's totally right, because there's still significant uncertainty there. But whilst those details are still to be confirmed, I think the principle is relatively clear. And that's that in future, multi-site employers, whether they're retailers, or care providers or even hospitality chains, for example, or potentially employers that have got more than one employing company in their group, are going to have to factor in the more onerous collective consultation obligations a lot more often than they do now. So quite a big shift.
Yes, because multi-site or multi-company changes that may not have triggered the obligations before because we were looking at individual one establishments, they might together trigger these collective consultation obligations. And now, obviously, the potential penalties are going up. So it's also worth flagging, I think, that if you have inadequate consultation, that can often lead to unfair dismissal claims. Yeah. And of course, we know that there are changes coming up to that. There is the reduction in the qualifying service. So employees who have 6 months service from the 1st of January next year are going to be able to bring claims. And also the cap is coming off the potential award for unfair dismissal claims. So that overall, the risk of consultation going wrong and not being done properly is going up hugely, isn't it? We're doing other podcasts on that. So look out for those.
I think so. And all of that actually sounds like really sensible advice because, like you say, risk is just increasing. Although it's probably worth issuing a health warning, I would say, that as with most legislation that relies on secondary regulations, the timing for these changes that we've talked about could still shift slightly. But having said that, the government is still publicly, at least, committed to the 2026 to 2027 roadmap for implementation that's already published. So with that in mind, we know they're coming. Employers should be thinking about what they can be doing to prepare for these changes. And I wonder, Leigh, if you could give us just a bit of an idea of what preparation might entail?
Absolutely. With the caveat that there's lots that we don't know yet, of course. I think my number one tip would be to keep a really close eye on the redundancies that you have in the pipeline and those that have already taken place. So how you record redundancies is going to become important. And really, it's all going to be in the planning and getting advice and clarity right at the early stages. Because if you might be making 20 or more redundancies across your business in the next year or so, then you might want to think about how you're structuring that and how you're timing that. And you might want to bring that forward before the change in the test comes in. Obviously, once we've got more guidance on what the new test is, employers should also review their policies and their procedures for how they go about their redundancies.
Thank you. Yeah, couldn't agree more. Bit of housekeeping, I think, is in order. And going forward too, they might also want to think about, I suppose, implementing just better workforce planning and tracking in general, because they'll need accurate real-time records and tallies of proposed redundancies across different departments, different locations, and the right people across the business will firstly need to talk to each other, and will also need to have visibility of all of this information to help them do this planning. So I think, like a lot of things in employment law, really, communication is probably going to be key.
So true. And also training, because they can only do these things if they know what's relevant. So upskilling HR, upskilling line managers, they'll need to be trained to know what kind of restructuring could trigger collective consultation, even if it doesn't look big at a local level. So making them aware of the fact that these changes are happening. They also need to feel confident and empowered, I think, to run these fair and robust consultation processes, particularly given the increase in the potential liabilities and the increase in the protective award if they don't. All of which I think really requires education and support throughout the business.
Yeah, I completely agree. You said it perfectly, because not doing that creates risk, as we've said. And so employers should also probably make sure that their risk assessments and their budgets, thinking more practically, are updated to reflect these increased potential risks going forwards.
Yeah, so it's all in their preparation and the planning, isn't it? Well, thanks, Chloe. That's all from us from Bellevue Law and the Bellevue Brief. We'll keep you posted about any future developments. And in the meantime, please share this episode with anyone in your business that you think might be interested in it.
Absolutely. And all that remains is to say thank you for joining, and we will see you for the next episode.